Ladies and gentlemen, this is a very unique opportunity that NUJS has as an institution. We have always had courses on media law which we had been offering to our students as a part of their optional elective course. But this has always been an institutional dream for all of us, that we will have a program which is attended not just by our students who have some background in the legal systems, but it is attended by people from the media. Because it is only through such confluence of differing backgrounds, differing professional identities, that we could probably have a very fruitful discussion on issues that concern the media and the legal system as such. And it has also been our dream that whenever we have such a program, this program is heralded by, shepherded by someone who is an expert from the discipline. Now, it is one such day when our dream is coming true. Fortunately, due to the University Grants Commission's Gian program, which is again a very interesting concept which has started last year, where we can invite, and the UGC provides the resources and the opportunities for us to invite eminent experts from other countries to come and address Indian universities, the students of that university, students from other universities, and professionals on certain disciplines of mutual interest, certain disciplines which mutually concern all of us. So it is one such occasion where we have a very, very eminent visitor with us. He has kindly consented to be a part of this exercise. He shall be spending the next 10 days with us, in fact a little more than 10 days with us. Professor Venkat Iyer. He's a very unique personality. On one hand, he's an academic. On the other hand, he's a barrister. And so wonderfully, he balances these two disciplines. That it's astounding. And he is a voracious traveler. He travels all around the world, delivering lectures on different subjects. And media law is one of his primary interest areas. So when we had the opportunity to engage Professor Iyer for these days, I thought that one of the first things that we should do is we should keep this program open not just to students but to professionals. And the press club has kindly consented to be a part of this exercise, to be a part of this dream. I'm eternally grateful to Mr. Snehashi Shur, who is the chairman of the press club. And the press club has invited working journalists, media academics, and today we have therefore a very mixed house. On one hand, we have the NUJS students who are studying in their 3rd and 4th years. On the other hand, we have working media professionals and people who are interested in the media as such. So with this very, very brief introduction, I would hand over the stage to Professor Venkat Iyer. It's over to him. He'll be with you for the next 10 days. I will hope that you'll cooperate with him, and all of us will collectively make these 10 days a very, very fruitful, a very, very engaging, a very, very thought-provoking session for all of us. Thank you very much.
Thank you, Shamik, for that very kind introduction. And can I first of all say a very good morning to all of you. I want to introduce my gratitude to a number of people and institutions that are involved in putting together this very promising course. I call it a course because that's, I think, what the official terminology is. I first of all want to thank every one of you for taking the interest in this subject and turning up. I genuinely mean that, because I can think of much better ways in which many of you can spend 10 mornings. And that you chose instead to come for a series of lectures on media law does show a degree of dedication, of interest, etc. So I'm very grateful to you. I am also grateful to NUJS for hosting me. I've never been here before, and it's all the more exciting for me to be here. Thirdly, I want to express my gratitude to Shamik Sen, who has been absolutely wonderful in the way that he has organized this event. He's been in touch with me now for a few months, and he has responded very promptly, very fully, and very enthusiastically to each of my emails. And although I only saw it for the first time this morning, I feel as if I've known him for quite some time. So thank you, Shamik. You have been absolutely wonderful. I want to thank also the Vice Chancellor of this university, not as a formality, but as a genuine expression of my gratitude. Because there were occasions, that is, there was one occasion when I had to seek his intervention on a logistical matter, and I have to say he responded extremely kindly and extremely positively, and I therefore want to put on record my appreciation of the Vice Chancellor, whom incidentally I have not yet met on this visit. I've seen him before, but I have not met him on this visit. I look forward to meeting him shortly. There is, of course, a bunch of people whom we don't normally see, but who are, I think, quite important to events like these. People whom we might call the backroom boys and girls, the administrative staff, who I'm sure would have assisted Shamik. And I want to place on record my thanks to them as well, even if I don't see them, because their contribution is just as important as the contribution of people who are up front. And finally, by way of thanks, I want to express my gratitude to the Government of India for the generous grant that they are making, not only to NUJS, but to a number of other institutions under what Shamik has already told you about, namely the Gian program. I think it's a very good way of encouraging interaction between Indian academics and academics stroke practitioners outside the country. So those are the people and institutions I particularly wanted to thank. Now I would like to say just a few things concerning this course, because it's better, I think, that we set out the ground rules before we proceed, so that we don't waste time on this on future occasions. Now, quite clearly, the scope of this course is media law, and therefore the focus of the course will be media law. Now, what I intend to do is to talk essentially about media law principles and their implications for journalists and for other media professionals. That is, if you like, my focus. I'll try as far as possible to keep what I say very practical rather than theoretical. Now, it's possible I may disappoint one part of this audience when I say that, because it is likely to be the case that some law students might want something more theoretical. I'm very sorry to disappoint you, because I have to keep in mind the rest of the audience. So I'm going to make it as practical as possible. The other thing I'll do is try to introduce a comparative element to what I'm talking about. In other words, I'm going to be giving you examples and cases from other countries, particularly Commonwealth countries, common law countries, because those are the countries that are closest to the Indian situation. And I would, of course, also be referring to Indian cases to the extent that I can. I claim no great expertise on Indian cases because I don't live in India, but I still would like to refer to them, including, incidentally, as I suspect there might be some interest in this, to the recent Supreme Court judgment on the right to privacy. So we'll talk about that as well. One of my challenges is that this audience is a mixed group. As I already adverted, there are a number of you who do not have any background in law. I think I'm right in saying that. In those circumstances, it would be unfair of me to take for granted a prior knowledge of law. So what I'm going to do is to lay the ground for my lectures by today talking about a few basic principles. basic concepts which I think are necessary for a better understanding of what I'm going to talk about in my subsequent lectures. Now that means a few of you, the law students, will have to put up with what might to them seem to be very boring issues. So I apologize for that. I am not going to pray if any of you in that category want to go to sleep when I do that. All I will say is, if you do, please don't snore. Other than that, you can switch off while I'm doing that. It is a price we have to pay when we have a mixed audience. So I hope you don't mind that. I'll try as far as possible also to move forward and give a fair bit of legal talk as well, which if any of you non-law persons are unable to understand, please ask me at any stage to explain better. I'm quite willing also to take up any special requests you might have. One of the things that Shamik has already told me is that some of you are interested in knowing a little bit about cyber law in relation to the practice of journalism. That is something which I'm willing to talk about. But do remember that our time is extremely limited. So I'll have to be brief. I will address those issues, but I'll address them towards the end of the course, not at the beginning, because we have to cover some very important topics first. So that's the way I intend to do. I want to encourage as much interactivity as possible. I want this to be a course where we speak to each other, not me lecturing down to you. Although of course I'll be doing a lot of speaking, but I really genuinely want you to ask questions, raise issues, share your experiences, etc. Don't feel shy. Don't feel nervous. It's a learning experience for all of us. I can tell you without any hesitation that I am sure if you begin to talk, I'll learn as much from you as you learn from me. So let us keep this as a forum for mutual exchange. Now, ideally, we are going to be we are going to meet for 2 hours every day this week and next week, Monday to Friday. And I know that some of you have to go to work after 12:30, so I don't want to keep you too long. If there is any scope for flexibility, for example, there are two topics that are very big, defamation and contempt of court, which I ideally want to have a little bit of continuity about. In other words, not break it up into 2 sessions, as you will see on the timetable. So later on, I don't want to spend any time on that now, but later on, if you do have time to reflect on this and tell me if on a certain day we can have 2 sessions or something like that. In other words, an extended session, then I would be very grateful to hear about it. Okay, but I'll leave that for another time. I also would like ideally to encourage group work, but I'm not sure if we'll have the time for that, because I've got a number of interesting cases which are suitable for group work, but I'll talk about them later when we have time. One last thing in terms of housekeeping. Any of you is very welcome to meet me outside the class if you have any questions, if you want to ask me anything. So I'm available. Just contact me after the class is over, okay, or before the class begins, because I normally start my day early. So I'll be here before 10:30, so you're welcome to contact me. Now, just a couple more things. Shamik has already given you what I consider to be a very generous introduction about me. Normally I would have liked to have an introduction from each of you, but I think if we did that, we probably be spending probably a half an hour or so, which I want to avoid, just because we don't have too much time. Okay, so I'll get to know you all in due course because of these 10 days. Just a couple of small things, but important things. Can I make sure that all of you have switched off or kept on silent your mobile phones, please, and any other mobile devices, I would humbly request you also to try to avoid texting, sending out tweets, checking Facebook messages, etc. in the course of the class, not least as a mark of respect to your fellow students. So please, Ben, I know that you must all be so busy that you want to be on your phone all the time, but try if you can for a couple of hours to resist the temptation to engage in any of those activities. Finally, I want to make this as pleasant an experience as possible. In spite of the fact that we are dealing with law, and it is not often that the word law and pleasant sit together. So even so, I just want you to be as pleasant as possible. So everything I've said so far will be geared to that object. Most important being interactivity. Okay. So having said all that, can I very quickly ask you, is there anything any of you wants to ask me before we start? No? Okay, in which case, let's then begin. Are you able to hear me at the back without that microphone? Yeah? Okay. I prefer to walk around a bit. Okay, so what I'm going to do now, today, is deal with some fundamental issues. And I have given the title there for the talk as freedom of expression, its limits, rationale for transit, and models of media regulation. Might sound very boring, but believe me, unless you have an understanding of these issues, you wouldn't be able to appreciate a lot of what we're going to be talking about subsequently. So I want to focus on that. As part of this discussion, I'm going to say one or two things which might be too simple, too elementary for the law students. So again, please bear with me while I do that. Today, I'm not going to deal with cases, but from tomorrow onwards, there will be lots of cases. Today it's only because I'm laying the ground for what follows. So very quickly, an indicative list of what we are going to be doing in the course of those 10 sessions. So this is what we will be dealing with today, and then we have, of course, defamation, which is, to my mind, the single biggest topic in media law. Then we have contempt of court, another very big topic. Then personal privacy, which is also going to be a substantial and substantive discussion. Hate speech and preservation of public order, which I think will also be very relevant to you, particularly the practicing journalist, given that in your own state of West Bengal, there have been a number of recent issues involving what broadly can be called hate speech issues. So I'm going to be talking about those things. Then copyright, which may sound a little odd, but which I still think is extremely important for you as journalists, and I'll explain why in due course. National security, parliamentary privilege. Parliamentary privilege I'm not going to be giving too much time for, partly because I have to prioritize. But national security, I think, will be also very important because, as you know, there have been a number of cases involving journalists where national security has been used to restrict free speech. For example, the use of sedition. So those sort of things also will be covered. And then, of course, I beg your pardon, copyright should have been taken out because I've already mentioned it. An overview of issues relevant to the regulation of online media. This is where the cyber thing comes in. So how does online journalism fare in relation to media law? And then finally, I'll be talking about administrative restrictions on the media. You may think this is a rather incongruous or trivial subject, but actually this has as much relevance as some of the other issues that I'll be talking about. Okay, so that's roughly what I intend to do. Now I want to talk initially very briefly about classification of law for the benefit of those of you who are not lawyers. And this is where the law students can probably switch off. And again, I'm going to be very brief. Why do I bring this in? I bring this in because I have noticed in the course of my interaction with Indian media, Indian journalists, that there is a lot of confusion and misunderstanding when it comes to the difference between, for example, civil law and criminal law. I'll give you a very simple example. Very often I hear somebody pop up on television in India and say, I am going to sue X or Y or Z because they criticized my dead grandfather. Now, if you did not understand the distinction between civil and criminal law, that would be a very stupid statement to make. Because as I will explain to you later, you cannot sue in relation to a dead person under the civil law of defamation, but you can under the criminal law. So there are those distinctions which I want to bring out. So, what's the difference between civil law and criminal law? Perhaps the best way of dealing with this issue is by asking, what are the purposes of civil law and what are the purposes of criminal law? So in other words, if you are bringing a case in civil law, what are you seeking to achieve? Can someone tell me?
In civil law, we demand compensation because there is no damage.
Right. And criminal law?
Punishment.
You answered it perfectly. The objective of civil law is to seek compensation, whereas the objective of criminal law is to seek punishment for the person who has done any harm or damage. And this has to be kept in mind because a lot of areas of law relevant to journalists would involve either civil law or criminal law or both. And therefore, you have to separate the two when it comes to particular situations. Now, it is possible for the same incident to give rise to both a claim in civil law and a possible action under criminal law. A typical example would be where copyright is breached. Now, if there is a breach of copyright, as I will explain later in greater detail, the person who has breached copyright can be made to pay damages for the breach. Equally, if the breach of copyright is a serious one, they can be prosecuted and punished, normally through the payment of fines. In copyright law, it's extremely rare, almost impossible for somebody to be sent to jail. But it still is the case that you have a criminal remedy. Now, I want also at this stage for journalists in particular to remember one thing, about which also I noticed there is a lot of confusion. That is the difference between damage and damages. I've seen a lot of journalists, and I'm sorry to say not just journalists, but even lawyers, sometimes use those two terms interchangeably. That is completely wrong. Why? Because damage means harm, loss, or injury. So you cause damage to someone. In a simple case, for example, if we talk about a hit and run case, motor accidents, you injure someone. In that sense, you're causing damage to that person. Damages, on the other hand, is a technical legal term which simply means compensation. So when you use the word damages, you mean compensation. A very easy way of remembering the distinction is by saying that damage leads to damages. Do not use the word damages for damage. Don't think damages is the plural of damage. You'll be completely wrong. And so when you report on these matters, you have to be very careful that you use the right terminology. So that's essentially the points I want to make in relation to the distinction between civil and criminal law. Then of course there is a distinction to be made between domestic law and international law. And I don't need to spend too much time on this because I presume most of you know what I'm talking about. Domestic law is law that applies within the boundaries of a country. International law, by contrast, is law that applies across national boundaries. So if you have a treaty which has been signed by India under the auspices of, let's say, the United Nations, then that would be the subject matter of international law. Whereas if you have the Indian Penal Code, which is the main law relating to crime in India, then that is a domestic law. The procedures for enforcement of domestic law and international law are very different, and that also needs to be kept in mind. From your point of view, the most obvious example of international law that applies on a practical basis would be copyright. Copyright is an example of a law that can be applied across national boundaries. Although of course you will still need the cooperation of the other country, but that is much easier done than in relation to a purely domestic law. So that's the simple point I wanted to make. Although I need to add that generally speaking, it is much easier to enforce domestic law than it is to enforce international law. Why? Because obviously there is no mechanism like an international police force that can be used to enforce international law. Central and state laws, very relevant to India. There are a number of laws in this country which, according to the constitution, come strictly within the domain of the central government, that is the union government. And likewise there are laws that apply only within a state. Again, very important for you people because some of the laws that affect you as journalists are state laws. Now what happens, for example, if there is a ban imposed on a newspaper, a temporary ban, only within the state of West Bengal? Can that newspaper be circulated freely outside West Bengal? Technically the answer is yes, but of course there will be a number of legal issues there. Likewise, there will be other factors that come in which make the whole situation quite complex. And this all is made even more complex by the fact that you nowadays have online newspapers. So what happens when there is an issue relating to a state which does not affect the law of another state, and there'll be matters that need to be resolved. If you're looking at it on the international plane, a typical example would be in relation to obscenity. So if you publish a newspaper in England which allows a degree of freedom that is not allowed in Saudi Arabia, say pictures of naked women or semi-naked women. Now you could, under English law, that would be legal. There's no problem at all. You can publish it. But what if that same newspaper was published online and was read by somebody in Saudi Arabia? There would be a problem because clearly Saudi laws do not tolerate the degree of freedom that English law tolerates. There are issues of that sort. But in any case, central versus state for the purposes of our discussion simply means that you have to bear in mind that certain laws have applicability throughout India, whereas other laws have applicability only within a certain state. Okay? Any questions so far? No? Okay, let's move on. Now, this might seem a very simple question, who makes law? But it's important to know because there are different sources for law. So, typically, the most important source of law would be Parliament or the state legislatures. In a country governed by a written constitution, Parliament assumes an important role, important position. So most of the laws are made by Parliament or a state legislature, and those laws are called statutes. You may have come across the word statute, statutory law, and that is law made by Parliament or the state legislatures. That is normally the highest lawmaking forum in any country. But then, judges can make law. This might seem odd, because most of the time you are being told that the function of a judge is to decide disputes. And yet, judges do have some power to make laws. How? They can make laws where Parliament has not made laws. But they cannot make laws where Parliament has already made a law. Now, in India, you have the advantage, if you want to call it that, of a judge in a higher court, that is either the High Court or Supreme Court, being able to strike down laws made by Parliament. In other words, if Parliament has made a law which is faulty because it, for example, contravenes fundamental rights, then a judge can strike down that law, which means that the law will have no effect. That cannot happen in my country. If the British Parliament makes a law, however absurd, no court in England can strike down a law. That is because we do not have a written constitution of the kind that India has. And the doctrine of parliamentary sovereignty is very strong in the UK. But for your purposes, it's very good because you have a system where if a judge finds that a law made by Parliament is faulty, then that law will be struck down. As happened, for example, with your Information Technology Act. I think it was Section 66A,
Yes.
which was struck down by the Supreme Court because it was not consistent with the provisions of the Constitution. And when a judge makes law, it is called common law. It's a slightly misleading phrase, but that is what it is. Okay, or case law, as a case. Yes.
So you say two things here. One, that a judge can make law where the Parliament has it, and B, it can strike down law, right? So sir, on the first idea there, so do you not feel that the only reason a judge can make any law is because, say for instance, that the Parliament does make a law and they can only interpret it because the moment, say at least in India, a judge like tries to make a law on something the Parliament has not spoken about at all, it like there is a question of separation of powers that come in, and thereafter that that isn't really law anymore because it is the Parliament that's supposed to adjudicate on it. So don't you actually think that the power of a judge to make law is derived from the fact that the Parliament can make law and they can criticize and change it instead of making something that the Parliament hasn't spoken about?
There are different theories for judicial lawmaking. One of which is what you just said. But in a country which is governed by the rule of law is applied very broadly. Now that we don't have the time to go deep into the subject, but essentially, if you have a situation where the rule of law is paramount, as is the case in a country like India, then judges have what is called residuary power. In other words, to do anything, and this applies also to England, to do anything that will further the rule of law. And I'll give you a very simple example with which I think all of you are familiar. You remember many years ago in India there was a case called the Vishaka case. Yeah, this was about sexual harassment. Now, what happened there was this: that a complaint was made by a lady about sexual harassment. When the case reached the courts, the opponent argued that there is no law forbidding sexual harassment. And that was true, because Parliament had not passed a law at that time which made sexual harassment of the kind that was alleged in that case. Now there are other provisions, for example, about eve teasing, etc. in your penal code, but that did not meet the definition of what happened in that case. So what the Supreme Court of India did then was to say, all right, Parliament has not made a law, but that won't stop us from dealing with this case in a fair manner. And the way we do it is we say that sexual harassment should be treated as an offense, as something that will not be tolerated. And that became the law of the land. But that only had force till Parliament passed a law on sexual harassment. So the way it works is that if the Indian Parliament had not passed a law, then the Vishaka guidelines would have continued till such time as Parliament passed a law.
Affidavit with nominations will also came from the Supreme Court judgment. Affidavit declaration of assets and criminal history of a candidate.
Correct.
Came from the Supreme Court judgment.
There are many examples of the court making law. So I hope that answers your question. That the court will step in when there is no law made by Parliament, but then the court has to be very careful that it doesn't engage in judicial overreach. Now that's a very big topic about which I'm sure you've seen articles, you've seen discussions.
She raised the correct issues.
Yeah. So what really happens with judicial lawmaking is that it has to be done very carefully. Now, as I said again, I don't have the time to go deep into this topic, but if a situation arises later, I'll explain it at greater length. But the short point I want to make is that judges can make law, provided Parliament has not made law. But very importantly also, judges cannot rewrite the law made by Parliament. So if Parliament has made a law and the judges don't like it, they cannot rewrite the law. Though having said that, in a few occasions in India, they have actually done that, except that they call it judicial interpretation, effectively saying something that the law never intended or could have intended. But again, I don't have the time to go into it. I just want to leave that as a thought for you to pursue in due course. So that's common law. Then of course you have law made by local authorities. For example, the municipality of Kolkata. Now when they make law, that is called secondary legislation or subsidiary legislation or delegated legislation. And that's normally done for matters which Parliament would not have the time to make law, Parliament of the state legislatures. But that's equally important. It is considered slightly inferior to statutory law. And then of course you have laws which are made by established authorities within village and tribal community groups, which is comparatively rare, but not unheard of. So if, for example, you have a mosque presided over by an imam, they have very limited authority to make laws in relation to certain matters that are within the province of Islamic personal law. Very limited. But even there, one has to be very careful. Any of those laws should not fall foul of the Constitution of India, which is why you have, interestingly last week, the talaq judgment. So issues like that also come up, but from your point of view, this is not very important, because in the area of the media, you don't have too many of those laws. And then of course you have laws which are made by the United Nations and other bodies, which broadly speaking can be called international law. Quite frankly, that is also a simplification, because international law itself is not homogeneous. There are different types of international law. But from your point of view, actually international law is relevant, because a lot of the time when you complain about some restriction imposed by the government of India, journalist bodies use Article 19 of the Universal Declaration of Human Rights, or Article 19 of the ICCPR, International Covenant on Civil and Political Rights. It is more a slogan than a statement of law. But it is something which is still worth keeping in mind. So you have all those things which are sources of law. Now, very quickly, this will be probably the most trivial. Sorry.
So I have two questions.
Yeah.
Can the court strike down a law which is only in contravention of something says the constitution or any simple or legal right that the parliament has made? The other thing is, what is the difference between a law and a rule? Like the Calcutta Municipal Corporation. Recently there has been a change in the taxation system in Calcutta. So while implementing these, many times the mayor said that we are making the rules. After we are done with the rules, we will implement it. So what is the differences?
Actually, the procedure to implement the act or the law, and there are several instances of court struck down certain portion of act. In RP Act, that's why the Lanu Prasad cannot contest in election. That is, I think, the 71A of RP Act, which the court has struck down.
Yeah. So the answer to the first question is yes, it is possible for a court to strike down the action of any public authority on the grounds that it is inconsistent with a law made by either the parliament or the state legislature, not only on constitutional grounds, but on grounds of administrative law. That's the difference between constitutional law and administrative law. Again, I don't have the time to go deep into this, but the short answer to your question is yes. The second question that you asked is in relation, just remind me what was it?
The difference between law and rule.
Okay. A rule-making power has to come from a law. So if the Calcutta Municipal Corporation makes rules, they cannot make rules that go outside the law. So for example, there will be a law like the Calcutta Municipal Corporation Act, which would have been passed either by Parliament or by the state legislature. More likely the state legislature.
Yes, yes.
Now when that happens, the Commissioner of the municipality will have the power to make rules under the law. Now if the Commissioner goes out of his way and makes rules that are completely unsupported by the law, then clearly those rules will be struck down. So there has to be compatibility not only with the Constitution but also with the governing statute. Okay? Right, let's move on. And I want to talk very, very briefly about this. Now, as I said, this is very elementary, but it's still important. The way the legal system is organized. And it is of practical use to you because, as journalists sometimes, you may have to contend with challenges to laws. So what happens? If you look at the graph there, the way it works is that you can divide up the legal system into two parts, civil and criminal. So on the left-hand side, I have given the names of courts that belong to the civil law system. So normally, if you have a very small claim, 10,000 rupees, something like that, you would go to the small causes court. I presume there is a small causes court in Calcutta. I'm not sure, but I know there are in other cities. And then if the amount involved is slightly higher, you go to the district courts, or in Calcutta, the city civil court. These are civil courts where you go for compensation. And then you also can take some of these cases in appeal to the High Court. Although there are many cases that you can take directly to the High Court. In fact, in most cases, you will be taking a writ petition to the High Court directly when it comes to fundamental rights, etc. On the other side, if it's a criminal case, for example, if any of you has been charged with sedition, then normally the case will be heard by the Sessions Court. But if it's a lesser offence, it will go to the Magistrates Court first and then to the Sessions Court. And again, there is an appeal to the High Court. So in a sense, the High Court is a forum where both civil and criminal cases are dealt with. Though of course, they have different benches for each of those things. And then of course, you have the Supreme Court of India at the top, where you can take cases from the High Courts. All this is very important because a lot of the time, when you have to challenge something involving freedom of the press, then your lawyer will have to make a strategic decision about which court to take the case to, particularly a decision between the State High Court and the Supreme Court. Because under the Indian Constitution, it is possible, uniquely, for a person to approach the Supreme Court directly for violation of fundamental rights. And a lot of people have done it and have achieved the results that they are seeking. So that is the hierarchy of the legal system. I've also put below there something called tribunals, which are becoming more and more important in India. You have a number of tribunals, especially in the area of employment law. So if you have, for example, a case of violation of the Working Journalists Act, then very likely that case will go to the tribunal, an industrial tribunal or employment tribunal, whatever you call it. And the tribunals are, strictly speaking, not part of the court system, but they are still connected with the court system. The other tribunal, which is very much in the news in India these days, is the National Green Tribunal. And there again, there are a number of cases which are of some some significance. So there you are. Now, in terms of the hierarchy of laws, again, I don't need to spend too much time on this, but I still want to just give you an idea. You have the top of the ladder, the Constitution of India, which is the highest law of the land. There cannot be any law which is higher than the law found in the Constitution of India. Then you have Acts of Parliament, which means laws made by Parliament or the state legislatures. But in India, you also have the slightly peculiar category of laws called ordinances. They're very controversial. Ordinances are intended to be on par with law made by Parliament, but only to be made when Parliament is not in session. In other words, it is more in the nature of emergency law, something that you need to do urgently, but cannot do because Parliament or state legislature is not in session. But unfortunately in India, there's been a huge history of misuse of the ordinance making power. And some of the ordinances do affect the press, very important. Then you have bylaws, rules, regulations, etc., which are examples of subsidiary legislation, delegated legislation, secondary legislation. All that would be passed by bodies which are below the state legislature or parliament. And finally, you have orders or notifications. These are laws made at the lowest level. So, for example, if you have the Commissioner of Police in Calcutta making a law restricting traffic for your Durga Puja, he has the power to pass an order which says on so and so dates no traffic will be allowed on certain such streets. That would be an example of the law. Do remember that every action by a public authority has to be supported by law. You cannot have a Commissioner of Police simply saying through a press release that he wants to ban certain things or ban traffic on certain roads. He cannot do that. He has to do it on the basis of a law. And the law that he will be using would be an order or a notification for which he has to show support in a statute. And that applies also incidentally to laws that restrict your freedom. So if, for example, there is a temporary order which says you cannot report on a pending case, then that has to be on the basis of an order. It can be a judicial order, it can be an order on the administrative side, but it has to be an order. So every action has to be supported by a law.
So,
Yeah?
can there be an administrative order dividing order to publish in the court proceedings? As you said.
Okay, generally speaking, no.
Yeah.
But there are certain exceptions which I will talk about when I deal with contempt of court. Okay? So the short answer is that in general terms, no. Okay? Now, I've covered the very fundamental issues of the legal system, etc. I want to come now straight to the meat of today's topic, and that is to take a look at what freedom of expression means. And if you don't understand this, you'll have difficulty understanding many of the things I'm going to talk about in subsequent lectures. That's why I'm going to spend some time on this. Now, I don't want to elaborate too much on the first point, namely the importance of free speech, about which I think most of us are agreed, particularly in a free society. I would, of course, make a distinction between the term democracy and a free society, because I would argue, maybe slightly controversially for you, that it is possible to have a free society without there being a democracy. Which is not to say that I don't like democracies. Please don't misunderstand me. I'm simply telling you as a matter of fact that you can have a completely free society without having democracy. Can any of you give me an example of a country where there is no democracy in the way that most people understand democracy to be, but where there's a lot of freedom? Bhutan? Sorry? Bhutan actually has democracy.
No, but
At least for the last 8 years.
yes, but previous to that,
Yes.
the first constitution was introduced by the fifth king.
Yeah.
So therefore, I think that would be a nice example.
Fourth king.
Fourth king.
K4. Yeah. Yeah. Bhutan is a good example. Bhutan before democracy. Okay. Yeah. Okay. Any other country? But you know, I will qualify your example of Bhutan with a couple of questions. Did Bhutan have a completely independent judiciary? I'm not sure. Okay. Any other example? Well, let me make it easier for you. I have in mind one country in Asia which did not have any democracy at all, but which had a completely free press, a very independent judiciary, and all the economic freedoms that you would want. And it was also, on top of everything, an extremely prosperous country. Sorry? Singapore, no. Singapore formally has democracy. Okay? Okay, let me clarify. When I say no democracy, I mean no right for people to choose their own government. No voting at all. Bahrain, would you call Bahrain a free society? I'd be a bit surprised if you did. Okay. Does Bahrain have an independent judiciary? I doubt it.
South Korea.
Sorry?
South Korea.
No. Well, South Korea has democracy in the sense of people being allowed to vote
The
periodically.
president is elected, yeah.
Sorry?
The president in South Korea is elected. The government is elected in South Korea.
Yeah, which means people can vote. I'm talking about a situation where people cannot vote. Sorry? Brunei? No. Not a very good example of a free society.
So are you talking about Thailand?
Thailand, no, well, Thailand also has democracy of sorts. People can vote. Although there are military coups every now and then. So, what else? Indonesia, not exactly. No. Okay, I'll tell you what. I'll put you out of your misery. I'm thinking of Hong Kong. Hong Kong before.
No, I beg to differ with you, sir.
Okay, tell me why.
Hong Kong was anyway under, it was a British colony.
Correct.
After that it came into the Chinese fold.
Yes.
And Hong Kong never really had the chance to enjoy freedom the way it wanted to. So, I mean, if you are looking at the definition of democracy and freedom in that manner, and taking your legal hat off, you cannot call it really Hong Kong. It never was a free country.
Okay.
Even sir,
Hang on, 1 minute. He's making a serious point, and I think we should deal with it. Did Hong Kong? Now let us talk of Hong Kong before 1997. Okay.
Yeah.
The first point I absolutely concede is that Hong Kong was a colony. No question about that. But did Hong Kong have a free press?
But that's slightly controversial. But
No, why controversial? No, deal with the point.
Let's talk about the separation part of it.
No, 1 minute.
No, just a moment. If you look at it from that point of view, you will have to take into account the views of the people in Hong Kong. Were they really given the right to secede from China and from Britain? Clear?
You mean self-determination?
Self-determination. They never really had the right to
It's
self-determination.
a different question altogether, other than like, isn't that not about free elections? So
You know what? I hate to stop you mid-sentence, but I take your point. I'm very happy to debate it with you. I was making
We'll do that after the class.
Yeah,
anyway.
correct. I was making a very, very simple point of the distinction between democracy and
But
freedom.
that's not a very simple point, sir. It's a very important
Well,
point.
it is in practical terms, it is something which is a good illustration, because to my mind, and you can disagree, I totally respect your right to disagree. The fact is, if you have a society that has an independent judiciary, a completely free press, and you can ask anybody in Hong Kong, either now or before 1997, whether the press was independent, and there would be no answer except yes, and also a degree of prosperity, which would be the envy of a number of other countries. And there being no democracy at all. Even now the democracy that exists in Hong Kong is a limited one. But we'll leave that for the time being, because we don't want to stray too much away from the topic. I'm very happy to talk with you later. I'm not ducking the issue at all, on the contrary.
Okay, let's not get understanding about this.
Yeah.
We'll talk about it later.
Okay.
And then
Now, therefore, in terms of the importance of free speech, clearly this is valued by all societies, and therefore it is embedded in law, and that's what we are going to be talking about. Interestingly, free speech values have been recognized well before they were introduced into international law. Because if you look at, for example, the Universal Declaration of Human Rights, that came only a few decades ago. But free speech values can be found much earlier than that in a number of other documents. And of course, you can think of freedom of expression either as a state of mind or as an enforceable legal right. Now, the concept of enforceable legal right is what we're going to be talking about, because much of our discussion is going to be centered around the position of free speech within the Indian legal system. Okay, so I'll be discussing that to a great extent. And then of course you have the very important question asked frequently: is free speech absolute? And the answer, I assume you'll all agree, is no. Just like any other right, free speech is limited and conditioned by the possibility of restrictions. If you want to put it colloquially, you could take the analogy of saying that the freedom of my fist ends where your nose begins. that is a concept adopted by law in most countries. That is, you can have free speech as long as it doesn't harm someone. And that is the kind of approach that the law takes. Now the difficulty is, where do you draw the line? And that is not easy at all. I do apologize. It's entirely shameful of me not to have switched off my mobile. Sorry. Sorry. The idea of absolute free speech is countenanced by no legal regime, because it is impossible to imagine a society that is orderly if you had absolute free speech, because you know the harm that can be done by abuse of free speech. It can either be private harm, for example defamation, or it can be public harm, hate speech. So for a number of reasons, speech is always restricted. Real difficulty is where you draw the line. And there are a number of cases which are very borderline, and those are the cases we'll have occasion to deal with when we discuss individual topics. Does freedom of speech have to have a preferred position in the hierarchy of freedoms? Now, if you look at legal literature, you'll come across many articles which say that free speech deserves to be put at the top of the hierarchy before any other freedom. Many others have disagreed and said no, you can have free speech given a lot of importance, but not necessarily talking of it as being higher than other freedoms. You then begin to think about the right to life and right to association, so many other rights, which also become quite important. So anyway, this is not something we need to bother about too much in practical terms at the moment, but it is something which I thought I'll put in just for you to think about. And then, of course, the Supreme Court of India itself has sometimes used flowery language, some might even say extravagant language, to describe freedom of expression. So I've just given a couple of examples. They have said that freedom of expression is the ark of the covenant of democracy, the most precious of all freedoms guaranteed by the Constitution, though I suspect, given the amount of activity that has recently been on Article 21, maybe the Supreme Court's views have changed, because nowadays almost anything can be derived from Article 21. So anyway, these are things that the Supreme Court has said. Also the first condition of liberty. That's also an interesting thought that the Supreme Court has put forward. But of course, there is always a potential for clash with other freedoms. It is something that we all recognize. I've just given the example of hate speech, but there are numerous other interests which can clash with freedom of expression. Very generally, I want to put a thought before you without going too deep into this. There is always a tension between freedom and equality. Think about it carefully. There is always a tension between freedom and equality, because one man's freedom often is a denial of equality to another person. There can also be a tension between freedom and dignity, so that your free speech can be an assault on somebody's dignity. So those are all issues which need to be kept in mind when you're talking about free speech or freedom of expression. And I want to talk a little bit about something else which is, I think, equally important. That is restraint, particularly restraint on the part of journalists. Now, what I'm trying to say here is this. The law gives you a number of freedoms, a number of rights. But do you always have to use those freedoms? I would say no. That's where self-restraint comes in.
So can you please clarify this point?
Yeah.
And can you elaborate on what you're saying?
Yeah, this is what I'm just trying to. Sorry, by the way, the mic seems to have died. Can you hear me at the back?
I can hear you.
Yeah. Okay, can somebody sort of help me with the mic? Because I have to strain. I would like to speak at a normal pace. Either a battery has gone or, yeah.
You want to talk about, yeah? So when you say that there is no absolute free speech in like say India regime and the Fusil's regime in United States.
Yes.
This is in the context of the Charlottesville protest. So I understand that the private harm still exists in the sense defamation is still a civil wrong there.
Yeah.
But what is the extent to which free speech causing public harm and where you draw the line in the US?
Okay. The US is the US stands out in this particular area. You're absolutely right. Partly because the Supreme Court of the US has interpreted the First Amendment to their constitution in a rather absolutist way. Again, not completely absolutely, but a simple example would be burning of the flag. You know those cases, right? But even the US does have a doctrine of real and present danger, which is used in the context also of free speech. So for example, I mean the most common example given is shouting fire in a crowded theatre. You know that phrase? Shouting fire falsely in a crowded theatre. Because what will happen is a lot of people will be injured. So that is a concept of public injury. But the threshold is much higher than the threshold adopted by England, by India, by Singapore, by Malaysia, any of the Commonwealth countries. So they do actually have more latitude for free speech than many of the other countries, but even they recognize limitations. And another example on the private side would be copyright. Copyright is strongly protected in the US.
Sir, you can deal on it later on also.
Sure.
It's a practical problem that we journalists often face. What you say, restraint. We are always told to be restraint is justifiably so for many reasons. But I think there's a fundamental right which allows, or the Supreme Court had interpreted this right to life and personal liberty, once they said the right to know about government activities. Okay, so when we journalists approach the government, our governments are very miserly in sharing information. It's very harmless enough was information about a project, about a flyover, anything. So most often government officers say there is an order that restrains us from speaking to the press. So these two are in clash with each other. One, you're saying the fundamental right says, I think it is this only, the right to life and personal liberty, where the Supreme Court interpreted one of this is also the right to know about government activities. When you're saying that it's a right of the people to know about government activities, and on the other side, the government is issuing orders to its own employees and saying you cannot speak to the press. So can journalists challenge it? And if we have a right to challenge it, where do we challenge? And I guess another example, which was a very bad experience for me, there was a case in Calcutta where doctors had beaten up the mason and he died. There was a medical college student. So when we were covering it, the Shialda court, the magistrate said, magistrate didn't tell us, there is an officer in charge, a policeman who is in charge of the courts. He said reporters cannot take notes. I found it to be absurd. He said the magistrate has said this. Because when you're allowing reporters to be present, you expect that it will be reported the next day. You're not allowing a reporter to make notes. So very naturally something wrong will come out. If you're agreeing that it will be reported, you should allow a reporter to take notes. So if this was so, I was told by my seniors that you should have told the magistrate there that you give a written order, we'll challenge it in High Court. So do we have that right to say, because since we don't know law, the judges and magistrates often say this is contempt of court, I'll send you to jail and all those things. So is it really that easy for them to say these things? So what are the rights of journalists in covering such things?
The short answer to your second question is yes, you can challenge it. Okay?
So can I tell the magistrate to issue a written order and challenge it?
I was just about to continue and say that this is what you have raised is very, very important. Even though you're talking about the lower court, but very important because this is a problem which journalists up and down the country face many times in their career. I will be dealing with that particular point at greater length when I talk about contempt of court. Okay, and I will also tell you what are the steps to go through when you're faced with that kind of situation. So I'll just temporarily leave it there. On the first question that you asked, also the answer is yes. Namely, it is possible for a citizen, not just a journalist, but a citizen, to challenge a denial of information by the authorities. The real problem is a practical one, not a legal one. The practical problem in India is again, I'm going to elaborate on this when I talk about RTI, data protection, official secrecy. They're all linked. Even the right to privacy, up to a point. Now, the practical problem here is this, that I hope I'm not being unduly critical of India. So I apologize if any of you feel offended. But the culture here is this. If you go to a bureaucrat in India, the first response for any question is no. You ask some of the most innocuous information, he will say no. Of course, you will be able to get the information later if you know how to get it. And the bizarre thing in India is, you don't get very trivial information, but for example, if you knew how to do it, you can get the mobile phone number of the Prime Minister. Seriously, I'm not joking.
Most of the answer in Parliament and legislation.
Sorry?
Most of the answer in Parliament and legislation is no, yes, no, or not.
Yeah. So anyway, what I'm trying to tell you is, there's a culture of secrecy. How can that be broken? Very difficult, but not impossible. It means the person asking the question will have to persevere in a big way. Now, up to a point, the Right to Information Commission is helpful. And I personally know of many cases where people have got hold of information that were denied to them doggedly by the government. They still got it. But after a lot of effort and wastage of time, you have to sometimes pursue these matters for 3 years, 4 years before you get even a simple piece of information. And secondly, it is hit or miss, because you sometimes go to the High Court and you get a very good judge who understands the issues very clearly and who is unbiased, who is subjective. He passes a very strong order and you get the information. So the picture is a mixed one. But the short answer to your question in law is yes, it is possible. Okay? And again, I'll talk more about this when I talk about RTI.
We bring a new law, RTI, and the
Yeah.
secrecy.
Exactly. So my point is that why doesn't any individual employee have the obligation to tell, like the government can restrict their employees from releasing any information. If a citizen wants to know, they have recourse under the RTI Act. But any individual employee cannot be compelled to give information at the drop of a hat.
No, well, you see, the point is, if the information asked for is routine, innocuous information, why should you compel the citizen to go through the RTI process? That's a very important issue on a practical level.
And also it's
Voluntary
time
disclosure.
consuming.
There's a provision of voluntary
It's also
disclosure.
time consuming. We lose time. I mean,
Correct.
we don't have that kind of time to
Absolutely.
make a
Newspaper cannot wait 30 days for the organization to which I am petitioning for a right to information. And then after 30 days they will say your question is not right, you have to appeal, and then stage it by another 30 days. So newspaper story cannot wait for 2 months.
No. So all the points that you're making are absolutely relevant, and I'll talk about them at greater length. I'll also give you examples of how these things are done differently in other countries, so that you have a comparative perspective. And I will not only compare India with the UK. I'll talk about Asian countries where these things are done differently, so that you have a better perspective. It's unfair sometimes to think of a comparison between India and a developed country. I can talk about developing countries where also there is a different approach taken to these matters. Okay. Any other questions? They're working on it?
Yes.
Yeah, okay. All right. Mindful of our other colleagues who are not as lucky as you to have a legal background.
As per section 21 of our constitution.
Up to a point. Because if you give it unlimited force, then your job as a journalist will be very severely affected, which I'll explain again when I talk about the right to privacy.
So you think that if it's a celebrity of a public person, he doesn't have a right?
I don't say he doesn't have a right, but he has a limited right. Yeah, it's actually very, very complex, as we will discover when we begin to look at the different elements of the right. I'm beginning to worry slightly about losing time because. Oh, here in the back. Okay. I was on this last point, important to restate. I'll tell you what I was intending to say in relation to that point. there is a concept of the right to offend, which is quite an important aspect of freedom of expression. I know that not everybody will agree with this, but I have to give you what are considered to be part of freedom of expression in most countries. So the right to offend means this: you as journalists, or for that matter anybody else, can say or write things which may offend other people. Does that mean that that should be banned? And the short answer in most countries is no. Because as part of freedom comes the inevitable downside of some people being offended. But simply because you have the right to offend doesn't mean that you have to offend, and the answer is no. That is where restraint comes in. In other words, the law gives you many freedoms, not all of which you have to exercise. But you can exercise them when it is appropriate to do so. So if there is an occasion when you think it is right to offend somebody because you're making a larger point for the benefit of society, then you should use that right. But at other times, you have to show restraint as a part of your conscience, whether you want to write something that will offend somebody. You don't have to be needlessly offensive. Now, how do you make that distinction? The distinction is normally made between law and ethics. Now, ethical codes require you to do certain things which sometimes are allowed, or require you not to do some things which sometimes are allowed by the law. But you don't have to do that. So, if you look at the Code of Ethics of a Journalists Association, the National Union of Journalists, or the West Bengal Press Club, or whatever. Now, that code will have many points. It will say, do not offend somebody, do not engage in writing that may be inflammatory, etc., etc. The provisions of that code may not be exactly matching the law. The law may be setting a standard which is slightly lower than the code. But you have to also have regard to the code, and that's because of your ethical commitment. So that's the difference between law and ethics. Now, I am focusing for the purposes of this course in my 10 lectures only on the law. I do actually do media ethics courses in different parts of the world where I deal with ethical issues, and there is so much to be said for ethical issues. They can quite easily do a 10-day course on ethics, but I don't have the time, and we are not doing that now. So please remember that distinction. That's all I want to say at this stage. That if you think about freedom of expression in a certain way, it is not necessarily all that you should be guided by. You should also be guided by ethics. Yes?
So, it's not a different question, but where do you draw the line between the right to offend and defamation? So, like, where would a journalist argue that it is my right to offend, and where would a defamation start in any particular case?
Very simply, and I will talk about defamation at greater length later on, because today I want to be very careful that I don't stray from the points I want to make. Defamation I'm going to devote a lot of time. It's the biggest topic. Simply, first point to make is that there is an overlap between the right to offend and the right to defame, or defamation and offense. There is an overlap. But where there is no overlap, the law has set a standard for what is defamation. And I'll explain that to you at greater length later. If that standard is met, then you are breaching the law. For offense, it is actually a more subjective standard, because you know that different people have different levels of sensitivity. You may feel offended by something I say, which your neighbor may not feel offended by. So that is more flexible, malleable, etc. And that's why ethical codes are usually much weaker than the law, or at least more flexible. But what I can do, I will not duck your question. I will very happily answer your question by giving examples, which we'll deal with when we're talking about the rights about defamation. Okay? Remember to remind me if I forget. Okay?
So, like a different question here. So, like in a country like India, exactly, the right to offend can be very different in different states. So, how do you think practically does it work out?
Okay. It will have to work out on a case-by-case basis. that is not an unusual standard today. In fact, if you look even at the recent Supreme Court judgment on rights privacy, as I understand it, the judges have been failed to say that you have to look at some situations on a case-to-case basis. Because, as I said, there is variation in the levels of tolerance, not only between countries but also within countries. Again, it's a point I'm going to deal with when I deal with definition. And as I said, if I forget, do remind me. Okay? Alright, let's move on. I'm very conscious of the fact that we only have less than half an hour. So I want to just deal with what else we need to tackle today. Now, there are a number of justifications that have been offered for freedom of expression. And I'm not saying this just as a philosophical exercise, because many of the things that we're going to be talking about in legal terms will have to be related back to some of these points. So I'm going to very quickly run through all this. So you would, of course, talk about freedom of expression being justified as an aid to the ascertainment of truth. So if you want to discover the truth or find out the truth, then of course you will have to have freedom of expression as a necessary aspect of that. And of course you have the theory of conflict of ideas in the marketplace. Then you have a justification offered for freedom of expression as providing individuals self-fulfillment. That also is something which is seen by many people as extremely important. And in terms of advancing that value in society, which most free societies do cherish. Then you have the possibility of providing for participation in decision-making by all members of society, which in a democracy is extremely powerful. Because if you do not have proper information provided to the voters, they will not be able to make an informed choice when it comes to elections, etc. So that is very important. And then, of course, also to promote social stability through discussion and compromise of differences. This is slightly more contentious because if, for example, you were to raise issues which are controversial, so a simple example would be Islamic law reform, which, as you know, has been raised in India, and some people have sometimes objected to the kind of language used when it comes to reform proposals, etc. But at the same time, how can society progress unless people discuss these things? Now, of course, you can have standards set for the kind of discussions you have. In other words, again, you can make your point in sober language, in language that is not in your face. All that would partly be the subject of ethics, but also to some extent controlled by law, as you will discover when I discuss the topic of hate speech. But it is important for promoting social stability and to also reform society. Now, if you go back to the history of a free press, then of course you had the concept of licensing of the press, which mercifully does not exist today. But in the past, if you wanted to, for example, start a newspaper, you would have to get a license. Not a business license, but a license in relation to the content. And that is seen as extremely antithetical to free speech. And of course you have Blackstone's observations about the liberty of the press. I want to make a very simple point without reading that quotation. And that is, there are two ways in which you can look at this problem. One is through what is called prior restraint. Prior restraint means you submit what you're going to publish to an official, usually called a censor. And that person will say whether it is acceptable for you to go ahead with the publication or not. This happens typically, for example, with movies, right? But on the other hand, you can have a different model, which is you go ahead and publish what you want to publish, but if you offended the law, if you violated the law, you will have to pay for it. You will have to pay for it either in terms of compensation, civil law, or in terms of punishment under criminal law. So that is not prior restraint. That is punishment after publication. So there are two models, and generally speaking, democracies or free societies follow the second model rather than the first, except in relation to motion pictures. Now, what are the other aids to free press? When I say free press, I include other media as well. Trial by jury, which doesn't exist in India, but which is common in many countries. But you have an equivalent of that in India, which is an independent judiciary. If you do not have independent judiciary, then freedom of expression is going to suffer, and suffer quite significantly. Why? Because there is a possibility of the harsh effects of badly drafted laws being reduced by an independent judiciary. An example being Article 60, Section 66A of the Information Technology Act. It was an independent judiciary that said that this law has been badly drafted, it cannot stand. If it did not have an independent judiciary, that would not have happened. Because the police will say, this is a law passed by Parliament, how can it disobey it? So you have the importance of the independent judiciary. Open justice, equally important. As part of an independent judiciary, you also have to have a judiciary that is transparent. So that in this country, for example, generally speaking, everybody is allowed to attend court, to witness proceedings in court. A judge cannot say, I will deliver justice in secret. It's not allowed, except in very limited circumstances. For example, blackmail cases or patent cases, etc. So it protects against judicial misbehavior or unfairness. So if you have a situation where people are not allowed to enter the courtroom, then what can happen is a judge, with only the parties around, can be very unfair, can misbehave. That can be checked by open justice. Also, it allows society to judge the quality of justice being administered. If you allow people to visit the courts, you can see the caliber of judges. Are these judges who know the law? Are these judges who do their job properly? All that can be assessed. Also, it deters perjury by witnesses. So, the fact that there is a public glare means that witnesses will be less willing to give false evidence. There is a disincentive for them to do that. And of course, it increases public knowledge of how the legal system works. I always encourage my media law students back home to go to court frequently, because that's the way they learn how the law is applied in practice. We learn a lot of things in the classroom. That's not enough. You have to see how these principles are actually applied in practice. And of course, media reporting of court cases. Is there anybody here, incidentally, who's a court reporter for any newspaper or television channel? No? Most of you keep away from the courts.
No, but then we have to go on case to case basis. Suppose
So,
we're covering something.
sometimes you might be
There is a
going to
designated
court.
court reporter.
Okay, but none of them is here. No, that's all right. Okay. And then I told you about prior restraint. The prohibition of prior restraint is also very important as an aid to freedom of expression. Where you have censorship, there is a greater risk of freedom of expression being stifled. And that is something which also needs to be borne in mind. So you have the Newtonian principle of publish and be damned. In other words, you publish at the risk of being made accountable for what you publish after you publish, not being restrained before. A few other salient issues, and that is to say that you can have the possibilities of varying levels of protection being afforded to free speech. In other words, you don't necessarily have to look at the protection of free speech being given a uniform level of aggregation. So some types of speech are completely disallowed. So if, for example, you're talking defamatory speech, that is totally disallowed. Others which are subject to contextual requirements, I would say the right to privacy is a good example. Commercial speech being given bigger protection than political speech. In many countries, it is argued that political speech, that is to say speech which is of public importance and not private benefit, should be given greater protection than commercial speech, that is advertisements, things like that. But there are certain countries where that principle is not accepted. Then you have the clear present danger test, which I made reference during the time we were waiting for the sound system to get fixed. What it means is that even in America, where free speech is given a much higher latitude, much wider latitude, there are restrictions put, but on the basis of a clear and present danger. In other words, does this speech, does the impugned speech represent a clear danger, a present danger to one of the protected interests? And if that is the case, the speech will not be allowed. But of course, their standards are more lax than the standards that obtained either in India or the UK. And I already told you about prior restraint and penalization of publication. Then, of course, special conditions are attached sometimes in relation to free speech affecting governments. So an example would be, and I don't have too much time to go into this, if you talk about broadcasting licenses, then there is a legal obligation in many societies for the government to be even-handed in the grant of those licenses. This is not directly about content of speech, but it is still important from the point of view of all fairness and aid to free speech. And of course, there's a possibility of discrimination in the enjoyment of free speech rights in certain countries, India being one of them. You know why? Because Article 19(1)(a) of the Constitution of India, which guarantees free speech here, only applies to citizens, not to non-citizens. Very important thing. We don't normally come across criticisms about that, but it is important. If I wanted to use that article in defense of something that bothers me, I will not be allowed to. Because as a non-citizen, I can't use that article. Of course, I have other legal rights, but I cannot use that particular article. So if you're a foreigner, then your right to freedom of expression in India is comparatively less strongly protected than if you are an Indian citizen. And that applies to a few other countries as well. Now, in terms of the status of the media itself, some countries do explicitly refer to the press or the media. Normally, they don't use this press because the concept of media is a relatively new one. It started as freedom of the press. But in many countries, including India, we don't have an explicit reference to the press or to the media. But it is still considered to be very much covered by the expression, freedom of expression. So that's what it is, and of course, I've given a few cases in which that principle was affirmed. And of course, in India, you have the additional protection given by the fact that that freedom of expression has been recognized by the courts as an integral part of the basic structure of the Indian Constitution. What is the advantage of that? The advantage is that governments cannot tamper with freedom of expression lightly, because if it is part of the basic structure, then that cannot be amended. And of course, there is a recognition of implied aspects of freedom of the press, for example, to disseminate information or opinion, and that in this particular case was affirmed in relation to the right of circulation of newspapers. That is to say, the government tried to cap the circulation of newspapers, saying you cannot print more than so many copies. And that was seen as a threat to freedom of expression. And the Supreme Court came to the aid of the newspaper and said, sorry, if freedom of expression means anything, it means the right of the newspaper to decide how many copies it's going to print. It's very important. You may think it's the right of the proprietor, but believe me, it's not. It is very much an aspect of freedom of expression. Now, in terms of the ambit of free speech under the Indian system, I just want very quickly to go through a few points, bearing in mind that I have only about 10 minutes left. So, you have, for example, the right to disseminate critical or controversial views. These are all recognized by the Indian courts as part of your right under Article 19(1)(a) of the Constitution. So, as long as whatever you say does not amount to incitement to violence, you can say what you like, however critical of any government. And it has been affirmed in a number of cases. I've just given a couple of cases there. Also the right to discuss social evils, which is, I think, very important, because as I said earlier, you cannot reform society unless you discuss certain topics, controversial topics, however uncomfortable it might be to certain sections of society. So for that reason, you need to have a wide latitude in your freedom of expression. And again, I have given a couple of examples there of the Indian courts affirming that principle, the right to express views or opinions which are outside the national territorial boundaries. Now, quite frankly, this is not very common, but there have been observations by the Indian Supreme Court, for example, in the Menaka Gandhi case, where the court tried to link the right to travel abroad, which was essentially the crux of the fight, with also the right to express yourself while you're abroad. I personally would have serious reservations about that approach, but that's what the court has said, so I can't argue with that. Also the right to engage in commercial speech. I was talking earlier about the distinction between commercial speech and political speech. The Indian courts have recognized that commercial speech is as much a part of the right to freedom of expression as is political speech. Also the right to reply or the right of rebuttal. Now this is also slightly controversial because not many countries would explicitly recognize such a right except in the private domain. What has happened in India is that the Supreme Court has, at least in one case, the Manubai Shah case, recognized that if a publication carried an article which was erroneous, then the person who was affected by the error can insist on a right of reply. In other words, to correct the error. Mercifully, the Supreme Court has confined that to publications that are owned or run by the public sector, not private sector. But whatever it is seen as another example of the court's willingness to expand freedom of expression. Also the right of access to state-owned media, which until a few years ago used to be a very big problem in India. And that is, I hope I'm right, I'm very happy to be challenged by somebody, the rather arbitrary manner in which the state media in India used to deal with certain topics. So if you were to produce a film, for example, which was not to the liking of the government, and then you went to Doordarshan and said, can you please show this film, even though it has won awards all over the world, Doordarshan will say, sorry, we can't show it, without giving any reasons. Now that arbitrariness was seen as antithetical to freedom of expression. Likewise, if you're in the old days, if you were invited to a discussion program on Doordarshan, and you participate in the program, and you said, or if you gave an interview to Doordarshan, and you were critical of the government, that interview will not be broadcast, even though you've been invited whether to give your views. It happened, for example, in the case of a lawyer from Bombay called Indira Jaising. She was invited by Doordarshan to give an interview after the Shahbal judgment had come out. And she gave the interview and made certain comments which the government did not like. And all that happened then was the interview was spiked. This is a pre-recorded interview, not a live interview. Okay. Now the courts have said, sorry, you can't do that, because if you're a public media, publicly owned media, then you have to be fair in the way you deal with these cases. I've been the case of Anand Patwardhan, who has had a number of run-ins with the government in this regard. And also protection against compelled speech, which is usually not available, and that was affirmed in the case of the IMPPA, where the question was, should theatre owners, cinema theatre owners, be compelled to show short documentary films produced by the Films Division before the feature film? They argued that these films were such a turn-off for the audience that it was just not worth wasting time on them. The matter went to court, and the court said no, it is justified, this policy is justified in the public interest, because we need to educate the people about the evils, for example, of dowry, of smoking, etc. And so compelled speech is not fully protected. The argument that compelled speech should not be enforced has not been accepted, and that, broadly speaking, would be consonant with the policy objectives of the state. It is sometimes referred to as a case of must carry. There are certain must carry obligations for television and radio. Now, in terms of freedom of expression in international law, you have various conventions and treaties that recognize free speech. starting with the Universal Declaration of Human Rights and also the ICCPR, both of which are coincidentally Article 19, which also happens to be the free speech provision of the Indian Constitution, completely coincidental. And then, of course, you have the European Convention, which has has a certain formula for restrictions. So what you will have to do is, if you're the government and you want to impose restrictions, the restrictions will first of all have to be necessary in a democratic society, not simply useful or convenient. They have to be necessary, and then they have to be proportional. So the restriction you impose has to be proportional to the objective that you're seeking. You can't just impose a restriction saying, it's very easy for us to meet the objective by banning a newspaper completely. That, of course, will not be allowed because the just proportionality will not be met. And also, there is this concept of margin of appreciation. Every state within the Council of Europe, to which the European Convention applies, has a margin of appreciation, by which what is meant is that you can apply the convention slightly differently in each country so that the country's cultural context can be taken into account. So those are the standards used by the European Convention.
So considering the idea of proportionality is something that's always been really disputed with regards to the threshold, and not just in media law, but a lot of international law, particularly in general. What is the threshold of proportional that is usually employed by the European Convention when they are assessing proportionality of an action with regard to restriction of free speech?
I would say you would then fall back on another concept which is sometimes seen as wishy-washy or controversial, and that is reasonableness. In other words, is a particular action proportional will be judged on the basis of reasonableness. Would most reasonable people consider it to be proportionate? To some extent, I know what I'm saying is a circular argument, but you can't go deeper than that. You cannot, because if you begin to be more prescriptive, then what will happen is you're going to tie the hands of the policymaker. So the courts will again go on a case-to-case basis and argue that what is being done is, in one situation proportional, another situation not. The safeguard against the judge making a mistake, because ultimately this will have to be decided by a judge, is the appellate nature of the tribunal. So that if you have a mistake made at the High Court level, you go to the Court of Appeal and then to the Supreme Court. So that's the only way you can deal with that. Yeah.
So this question of proportion wasn't built up as a response to the inadequateness of the legislative institutes by the British courts. Because as far as I'm technically that name of the other that said that, but I think there the process says that it was so Wednesbury reasonableness was failing to cater to the needs of the changing society, and thus they developed this concept of proportionality. So in that light, if proportionality relies on reasonableness, then how are we moving on?
We are not. In fact, there are many articles which, first of all, I don't have the time, and secondly, it will be very boring for our non-legal friends. But you raise an important point. I'm very happy to discuss it with you later as well. There are many articles which actually argue that the proportionality test is no different from Wednesbury unreasonableness, etc., or even the simple concept of reasonableness, right? And also that why should something that has worked for so many centuries be replaced by this new test? Is the argument made? Now, remember that the incentive for this came from Europe rather than from within England. So it is not that the English judges decided that Wednesbury unreasonableness was inadequate, but it is simply that this concept had come from outside. And remember, there is an obligation on the part of all member states to follow the jurisprudence of the European Court of Human Rights. That's the reason it happened. Okay? Right, let's move on. Now, in terms of censorship, again, I'm not going to spend too much time on this. It is of course contentious, but it is permissible under most legal systems. So there is no absolute prohibition against censorship. Although, of course, censorship is generally disfavored. Now, in India, censorship is not constitutionally invalid, and there are judgments which clearly indicate so. But a number of instances of censorship have been challenged, usually on administrative law principles, although they use constitutional law as well. And an example is the case of Vibhuti Rao and Wbnujs, which was one of the cases that happened during the emergency, 1975 to 77. Many of these cases resulted in the court holding that the kind of censorship that was practiced was illegal. So this is what the court said in that particular case. Merely because dissent, disapproval or criticism is expressed in strong language is no ground for banning its publication. You can see the approach that the court takes, and I'm sure if a case like that came up today, the court will be equally strong in its condemnation of that kind of censorship, but not censorship as a whole. There may be circumstances where censorship would be justified.
So this is the Bombay High Court judgment?
Correct. It is the judgment of the Bombay High Court, the Vibhuti Rao case. And of course, if you want to talk in general terms, censorship is the exception rather than the rule. It does not apply to motion pictures. So it has been clearly established that censorship, what sometimes people call pre-censorship, it doesn't have any meaning according to me, but censorship is tolerated, accepted in relation to motion pictures for the reason that motion pictures have a much greater impact on audiences than newspapers or books and other media. Okay, very quickly, what are the purposes of media regulation? In other words, why are media being regulated? What is the justification for regulation? Again, because we don't have the time, I'm going to go through it very quickly. I noticed incidentally that just past the 2-hour limit. Can I have your permission to just go on for another 5 minutes?
Yes.
Yeah, if you don't mind. It's only because we had to spend some time dealing with the audio issue. Okay. What are the purposes of regulation? There are some state-related interests which have to be protected. For example, national security. What I'm trying to say now is, why are you as journalists being prevented sometimes from saying something that you want to say? I would submit that there are many sources for that prevention, for that restriction. So, state-related interests. Also, preservation of public order and tranquility, which would mean, for example, that you don't say things that are likely to incite people to violence. An example is what is happening today, as we speak, in Haryana. You know that the man, Gurmeet Singh, is going to be sentenced, and there will be restrictions put. A starting point is that all mobile data services have already been completely stopped. Now that's a restriction on expression, but that is justified on grounds of public order and tranquility. Also prevention of certain harms. So children have to be kept away from undesirable content, and that is the reason why certain content will not be allowed, even if it means that there is a denial of freedom of expression on the part of people who produce that content. Also mentions of standards of decency. This is very debatable. It's controversial because what one person considers to be indecent, another person may not consider it to be indecent. But that's all. And in a society where these values are respected, there is a degree of consensus that restrictions can be put on that ground. Also compliance with international obligations. There are certain things which can be restricted on that basis. Promotion of cultural norms, national language. In some countries, you have a rule which says, I'll give you an example of a country near you, which is Bhutan. A rule there says that if you wanted to produce a newspaper, now most newspapers in Bhutan are in English. But if you want to publish an English newspaper, you have to also publish a Bhutanese version, a Dzongkha version, this is a national language, with the newspaper. So you'll find most newspapers in Bhutan, English newspapers, have a fold-out section in Dzongkha. And many people take it just as a formality, but they have to do it. It's compelled by the law. Also avoidance of monopolies or other competitive practices, which is justified on grounds of equity. protection of private rights, for example, reputation, which means that you can't write defamatory articles. Protection of other legitimate interests, intellectual property, which is why you have the law of copyright, and of course, promotion of technical efficiency, standardization of practices, which applies incidentally if you're running a radio station or a TV station. So you have to comply with certain technical requirements. What are the types of regulation? Again, going to be very brief. You can either have what is called statutory regulation, legal regulation, which is basically law passed by Parliament, hard law. And these are accompanied by strong sanctions. So there is the possibility of a penalty, there's a possibility of fines, etc. And these are used to protect or promote interests capable of legal control, defamation, copyright, etc. Voluntary regulation, which is self-regulation, and this is based on soft law. By soft law is meant codes of conduct. An example would be the press club. If the press club has a code of conduct, it is soft law, it's not hard law. And of course, it has very weak sanctions compared to hard law. And it's usually used to protect or promote interests that are not amenable to legal regulation. So, matters of taste would fall under this category. And then you have what you may call a hybrid type of regulation. That is, you have a degree of autonomy given to the media, to the professional group, but with a degree of state control. And a typical example of that can be found in India, which is the Press Council of India. The Press Council seeks to encourage voluntary regulation, but the Press Council of India Act is a law passed by Parliament, and the government appoints members of the Press Council. So it's not entirely done by the industry. Okay, so that's the typology of regulation. Now, just a few considerations before we wind up. There is clearly a tension between freedom of expression and regulation, with which I'm sure you're familiar. And this is usually sought to be resolved by a number of legal, economic, ethical, cultural, and practical safeguards so that the regulation doesn't become too harsh. Although regulation is accepted as necessary, if the regulation becomes too harsh, then it takes away freedom of expression. That should be avoided. So you need regulations, but only to the extent that the regulation protects certain societal interests. And that balance is not very easy to achieve. And of course, you need to have variable approaches between media sectors so that a type of regulation that you apply to the press may not always suit television or radio. So sectoral differences are inevitable. And of course, also differences in approaches and outcomes between countries. I've already given you the example of a huge difference in approach to regulation of pornography between the West and Saudi Arabia. But remember, even within Western countries, there are differences. So, to the extent that pornography is much more freely available and tolerated in Scandinavia, but not in England, itself shows you how even in Western Europe they have different standards. So there is inevitably a possibility of standards being different between countries. And of course, you need to recognize the changing media environment, cultural shifts, advances in technology. Advances in technology I'm going to talk about when I talk about cyber regulation. What are the considerations that weigh in that context? And of course, it's very important to recognize the position of the public interest, because in many cases, something that may be forbidden by the law would be allowed if there is a sufficiently strong public interest. A simple example would be sting operations. You know that generally speaking, what is involved in sting operations is prohibited by the law, because you're invading somebody's privacy, etc. But the law will excuse you if you engage in a sting operation if you can show a very clear public interest in what you're doing. And I'm going to talk about this at greater length when I discuss personal privacy. Now, what are the safeguards that you have in relation to regulation? Because in law, there are issues to be considered about issues to be considered to prevent harm being done by regulation. And those safeguards are, again, I'm just going to go through the list without elaborating on them. Legality, in other words, any restriction imposed has to be legal. Necessity, is a restriction necessary? If the answer is no, the restriction is bad in law. Proportionality, we already spoken about. Non-discrimination or fairness. If you said that we're going to impose a restriction against the media, but it will only apply to media owned by Hindus, that would clearly be untenable because you're engaging in hostile discrimination. Principle of transparency. Normally, when a restriction is imposed, it has to be done transparently. Principle of consistency. There has to be consistency when it comes to imposition of restrictions or generally in the area of regulation. Also certainty and stability. You can't have regulation changing so frequently that people are unable to take decisions, and therefore a degree of stability is necessary. Retroactivity. Generally speaking, you don't impose a restriction retroactively. In other words, you don't impose a restriction today and say this should be applied from last week. Normally it's not allowed. There is no absolute prohibition against it, but generally it's disfavored. And of course, principle of simplicity, which is not a legal requirement, but it's good practice. That if you are regulating, you regulate it in a manner that is relatively simple. In other words, don't make regulation needlessly complex. That is again a principle which is often accepted. And of course, you can have different levels of regulation. And generally speaking, of course, regulation is low in relation to the press, but higher in relation to broadcasting. And of course, you can have different types of regulation even within a sector. So you can have regulation of infrastructure, distribution, access, content, etc. What are watershed restrictions? Watershed restrictions are that, for example, if you run a TV company, TV channel, and you show content which may not be suitable for children, then for example in the UK, we have a rule that says those programs can only be shown after 9 p.m. because the assumption is that children don't watch TV after 9 p.m. Of course, that is not necessarily an assumption that is currently valid, because we know that children A, stay up late, and B, they can access the same content on their mobile phones or iPads or whatever. But anyway, it is a method of regulation followed. And of course, you have challenges from convergence, which is what I was just talking about. And then you can have differential regulatory burdens on publicly owned broadcasters and commercial broadcasters. For example, there are certain restrictions imposed on public service broadcasters which are not imposed on private channels. International regulation is usually quite weak, and it's based on mutual cooperation rather than hard enforcement. And it's strong in relation to technical standards rather than to content. Of course, it's gaining greater attention with the advent of the internet, in particular against child pornography. There's a lot of international cooperation emerging. Even then, it is weak. It is still quite weak, but there is more agreement in that area than there is, for example, on taste and decency. And this is the last slide, just to give you an overview. Clearly, the impact of technology has to be kept in mind when we are talking about the future of regulation. Also shifts in political economic ideologies, and you have the phenomenon of globalization, which has to some extent impacted on media regulation. There are reductions in subsidies for public service broadcasting and its consequent replacement by the commercial sector. So on the one hand, you can say that the number of channels has increased and people have been given a wider choice. But on the other hand, you can argue that the overall quality of television has decreased despite the increase in the number of channels. And there's growing internationalization, also homogenization of content, which sometimes people disparagingly refer to as the McDonaldization of content. So a lot of American content which is being circulated in many countries, Then of course the dilution of natural cultural pressures in the case of easy availability of foreign content, which also in many countries is a worrying issue for policymakers. And the final point I want to make is that in spite of everything that I've said, the need for regulation is not going to go away. Regulation will continue no matter how much of expansion there is in the media sectors, because there are certain values which have to be protected at all times. I really am very sorry that I had to rush through the last bits, so please accept my apologies. And if there are issues that you are dying to ask me questions about, I'm very happy to answer them, either for those who are willing to stay back or on a future occasion. Thank you very much.
Thank you.
Is the